This is The Law Show on CL 650. Now back to the show.
It's illegal, it's immoral, or it makes you fat. There you go. All right, it's The Law Show here on CL 650 for another Sunday morning. Sterling Fox with you, joined in studio by John Lakes and John White, lawyers both and partners in Lakes White LLP in North Vancouver. On the program today, we're talking wills and estates, specifically as spouses are affected. And John Lakes, you mentioned something during that quick break we just took about kind of an old law thing that may still be lingering in the minds of many of our listeners and having to do with a will being voided after a person gets married. Explain that one.
Under the old law until March 30th, 2014, if you became married, then any will you had prior to your marriage became void upon marriage.
Oh.
And that was particularly an issue sometimes with common law people, because the only time a marriage remained valid is if it was made with the intention to get married. So let's say you're going off to Cancun to get married.
Right.
And you'd say, oh, I plan on getting married the 15th of June 2015 in Cancun, and so the will would remain in effect.
Right.
So with common law families, it was quite often an issue because they do a will leaving everything to each other. And we may put a clause in there saying, if we do get married, the will remains in effect after a marriage, but with no specific date. And of course, you have people go to Las Vegas and they do really well, and next thing they're before the Elvis impersonator and they're legally married. So when they got married, all of a sudden, when one of them dies, then you get back into the Administration Act where you die without a will.
Right.
Now, under the new act, when you get married, your old will remains in effect. So
it doesn't cancel automatically anything you had before.
So you may still have, first of all, you may not have any provisions for your new spouse in your will.
Right.
And second of all, you may have provisions for people you no longer wish. So when you get married, you've got to get a new will, because the old law doesn't apply anymore, and other than sometimes it's worse to have an old will than no will, because your will may have been done 25 years ago,
but it's still valid.
Yeah, well, but a lot of people don't know that. It was pretty widely held in the general public that a will became void upon marriage. A lot of people knew that.
Right.
But now when I'm talking to my clients, I have to educate them, because they realize
that's not
no
the case
longer the
anymore.
case.
Well, and this is all recent with this Wills Estates Succession Act, or WESA, John White.
Right.
It's caused a lot of changes, including tossing that old notion right out the back door.
Well, it certainly has.
Now, you brought another case with you. You've been flipping through the pages here as John and I have been talking, and this is an interesting case. This is in the Supreme Court of British Columbia, and it's dated 2015, and it's McRae versus this is the is this the Perry case?
No, Buell.
What I thought we might look at is a case called, or what I had in mind was a case called Buell and Unger, which is actually a case that came out before WESA came into force.
Oh,
because WESA only came into force about 18 months ago.
That's right. You just said that a few weeks ago.
And this is a case from 2011. But it's what we found interesting about it is that just because one party to a common law relationship thinks that they're in a marriage relationship, that doesn't mean that the other party agrees with them. This is a case. It
seems odd at first blush, but when you think about it for a second, it does suddenly become possible. So how does it work its way through? Well, I could maybe see how that would happen. How does it work its way into becoming a court case?
Well, I mean, court cases come from all sorts of odd scenarios, but a lot of court cases come about because there's uncertainty. And a lot of wills cases come about because there's uncertainty. A lot of uncertainty is caused when people don't have wills, and this is one of those cases.
Okay.
Where the gentleman who died didn't have a will.
And so this is the second example that
Right.
we're seeing today,
Right.
a court resolving a situation in which there was no will to work with in the first place.
Well, that's right. And he'd been married before, and he was in the process of getting divorced from his first wife. But in the meantime, there was another woman with whom he'd been in what I'll call some sort of relationship.
Okay.
And the issue for the court was, what kind of relationship was that? And in particular, did the evidence show that he'd been living with this woman in a marriage-like relationship for at least 2 years?
Okay.
And if the answer to that question was yes, then she's a spouse, and she is first in line to inherit his estate. If the answer to that question is no, she's out of luck. And so that's what the court had to determine. And of course, he's no longer there to testify.
And there you go again, right? Okay.
So the court is looking at this case as litigators have to do, as barristers do, through the rearview mirror.
Right.
And so the woman in question, who claimed that she was a spouse, brought forward evidence that they'd lived together, that they'd spent many nights together, that they were a loving couple, but that they kept their relationship secret for various reasons.
Not the least of which was that technically he wasn't divorced yet, and that sort of thing. So how long, though, had they been together? Did the court establish, according to your partner's definition of 2 years in a marriage-like relationship, did exist or not?
Well, I mean, we always cut to the result. It's kind of like flipping to the last page of the mystery novel to find out who done it. In this case, the court found that the woman in question, who had the burden of proving that she was living in a marriage-like relationship
because
with this
she
gentleman.
brought the case, right?
Well, in this case, she was actually the defendant, but because of the nature of the case, she was the party who had to prove that she was
okay,
and in a marriage-like relationship, living with him in a marriage-like relationship for at least 2 years, and she failed to do that. What the court found was that they did live together for some periods of time, but she had a condo in Tawasin, and he lived a lot of the time on a boat moored off Salt Spring Island.
Oh.
And yeah, they visited each other overnight, but they didn't live together for 2 years, in the 2 years before his death in particular. It was just some of the time. There was also a real question in the court's mind as to whether their marriage was, or their relationship rather, was marriage-like, or whether it wasn't. And the court wasn't persuaded that they were in a marriage-like relationship. I mean, they kept their finances separate.
Right.
They lived in separate locations.
Right.
Neither of them had legal rights to the other's living quarters.
Mm-hmm.
The gentleman wasn't on title, for example, to
her
this woman's
condo, right?
To her condo, as an example. And the court's looking at things like that. One of the interesting points for me in this case was the fact that they kept this relationship secret. And of course, everybody's got a reason for doing that.
Right.
But the court found it significant that they didn't really portray themselves as spouses to the general public. And really, what it comes down to is the woman who bore the burden of proof certainly seemed to think that she was in a marriage-like relationship
but she
with
couldn't
this gentleman.
convince the court. She couldn't prove to the court that she was.
What she couldn't show was that he thought that way too.
Ah.
And we're back to the point of intention. We were
right.
talking about earlier. That part of the piece was missing, and that seems to have been fatal to her position in this case. And at the end of the day, the court rules against her, and so she was out of luck.
Out of luck meaning what in this case, John? Was she completely disinherited by the estate then?
Effectively, yes. There's no will here, so she is no longer the party to whom this gentleman's property passed under what we call intestacy, which is the situation you have when there's no will. There's a bunch of rules that govern where your property goes if you don't have a will. Suffice to say that the spouse is first in line. This woman was trying to persuade the court that she was a spouse,
right,
and she failed to persuade the court.
Interesting. So then, John Lakes, you're back to that at-risk scenario that you've warned our listeners about earlier. Here's a woman who was pretty convinced that she was in a relationship, a marriage-like relationship, which we call common law, of course. And the court said, no, I don't think so.
Well, I mean, I think people are foolish to think common law is the same as being married. It's not. And it's all the reason why you want to have it in writing prior to the person's decease, because if you're waiting until after that person's died, well, there's only one person who can give evidence, and that's yourself. You don't have anybody on the other side to back you up because that person's gone, and
Right.
at this point we have no ways to communicate to somebody in the death. So
Interesting stuff. And fair warning, you heard it here on The Law Show on CIL 650, and we're back with more right after this quick timeout.
There's more of the show still ahead. This is The Law Show on CIL 650.